Katrina Sauls, which asked for her damages for loss of earnings. Plaintiff did not object and has referred us to disclosures, but as of their most recent disclosure filing, they have not provided any calculation for loss of earnings. So we're asking that plaintiff be compelled to provide that information either in their interrogatories or their disclosures.
Or you're going to be required to provide a calculation of the lost wages.
And if we don't, we can't present them at trial. It's my understanding, Your Honor.
Right.
Yeah.
You can do that within the next, let's say 2 weeks.
Past lost wages calculation, it's my understanding earning capacity does not need to be calculated. Is that,
If you have a situation where they missed 8 weeks from work, then you need to calculate that out and give it to us. If it's just a capacity issue, then you're right, it may not need to be calculated.
Thank you. Got it.
All right. The next one is interrogatory number 8, also to Katrina Sauls, which asks if any physician has told her if she will need future medical care treatment and to identify the provider and the treatment. Plaintiff refers us to the disclosures, but we don't believe that's a sufficient response. We're asking what the plaintiff's understanding is of what future treatment she may need in the future, and we believe that
Motion to compel is granted. You need.
I already agreed to that one, Turner, or Mr. Field. I said we'd supplement number 8.
Okay. All right. Thank you. Moving on now to the request for reduction number 8 to Katrina Sauls. We asked for calculation on the loss of wage. This asks for supporting documentation for the loss of wage claim from the date of the incident to present for any lost wages. We believe, again, that's relevant.
Yeah, I didn't object, but I understand the court's ruling on the previous issue, and we will comply.
All right. We have two, one to Katrina Sauls and one to the minor as part of request for reduction, asking for letters of protection. Plaintiff has objected that it's overburdensome or protected by attorney-client or attorney-work product. We believe those are clearly relevant. If any physician has a financial interest in the case, that those should be reduced both with respect to Ms. Sauls and her minor child.
So under the NRA Auto Crushers case and its progeny, what is the current status on LOP production? Has the Supreme Court specifically stated that that's discoverable or not? I don't think they have, but may not be 100% up on that.
So my understanding is that they've said that can be discoverable because it
isn't mandatory. I don't believe they've said that, but that I may be wrong on that. At this point, I'll go ahead and sustain the objection, but if you want to brief that issue and look at because there's a number of NRA Auto Crushers and a bunch of other cases, the Supreme Court is really interested in this area. So, if the Supreme Court has spoken on this and requires production of LOPs, obviously I'm not going to disobey the Supreme Court, but so don't mandamus me without bringing me a trial brief first. I don't think they have, but I know that there's been a lot of discussion about it. So if there's something on point that says it's required, then I'll obviously order it. If it's not required, then I'm not.
I don't believe there's anything that says it's required. I did look at that issue before the hearing. But if there is, we'll certainly bring that to the court's attention.
Okay.
Last issue, and we requested medical authorization from the plaintiff, and I understand they don't necessarily have to do that, or we asked for records. But one of the issues that's come up is plaintiff identified her family physician, Dr. Monica Hearn, in her interrogatory responses. And we want to send a DWQ to this physician to obtain records for the last 7 years. Plaintiff's counsel, I believe, is going to object to that. And so we just want to have that addressed before that gets sent out.
I have a very standard way I deal with this in virtually every case. And that is I allow discovery of any medical condition related to the plaintiff that is 5 years prior to the accident that they're claiming in the subject accident. So they have a sore neck, any treatment to the neck. If they have a broken arm, any treatment to that arm for 5 years prior to the accident, post-accident. But if it's something, for example, they have I don't know, it's a back injury and they had, knee surgery 7 years ago or 3 years ago, that would not be discoverable. So that's how I've been doing this for 15 years. So does that help answer the question?
It certainly helps on the 5 years. I think it's a little unknown, given that this is what appears to be a family physician, of whether or not any issues with, soft tissue, spine, back. If there's, I don't know if she's made complaints in the past, and so
what I would do in that situation usually is, and there's a standard order. I'm sure Mr. Lohr has a copy of it that kind of is floating around that if you do really want to get the family physician's records, it would go to Mr. Lohr first. He'd have an opportunity to review them, withhold any that he feels like is privileged, and then give you anything that's not. And then if you feel that that's been done improperly, then you can request an in-camera inspection. That's how I've done it in the past. Mr. Lohr, do you have a copy of that order?
I think so. I feel confident we've got one of those.
Yeah, so just go ahead and put one of those together for this.
okay, yeah, no objection to that. All right, I believe that the other the issues plaintiff's counsel has agreed to supplement or produce responsive documentation. So I think that's all.
Okay. Give me an order on that, Mr. Field. For the order, Mr. Field, make sure
Yes.
you do it this way. At the beginning, instead of on this day, put on August 22nd, 2022. Make sure that you share the order with Mr. Lohr. See if you guys can't work out an agreed form of the order. Get me the order by this Friday. So please don't wait 8 months to get it to me. Get it to me by this Friday.
Okay.
All right.
Do you want us to put on the record the issues that we resolved to include as part of the order?
That doesn't. I don't need to, but if you want to, you can.
Okay. All right. All right. We'll get that order to you then.
All right. Thank you so much, Mr. Field. Mr. Lohr, you guys have a great rest of your day. Okay.
You.
Thank you, Your Honor.
All right. Are both sides here on Crapal versus Combs?
Yes, Your Honor.
Yes, Your Honor. Let me get my camera on. Or did I turn it on?
Are you a Zoom user? You need to have your name on.
Your Honor, this is Kit Galini. Is my name appearing or not?
No, it says Zoom user.
And I don't know whether I can. We lost everything at my building yesterday and today and at home. And so I am Zooming on my cell phone the best I can.
Okay,
So
that's fine. That's
is
fine.
there an easy way to do it? I'll do it happily.
I might be able to do it for you. Let's see.
I just don't want to become a cat or anything because that was so quickly.
Let's see. There you go. We got you fixed.
That is perfect. I appreciate it, Your Honor.
All right, Tony, let's go on the record on DC 19303A, Crapal versus Combs. Counsel, make your appearances.
Your Honor, this is Maureen Farrell appearing for plaintiffs and counter defendant Crapal and Renninger.
John Galini for defendants and counter plaintiff, Michael Combs Properties LLC.
All right, we're here on a motion, plaintiff's motion to enter judgment based on a jury verdict. This was a case that was actually tried. I don't use visiting judges that often, but he was tried by a visiting judge to a jury verdict, as I understand it. Is that correct?
That's correct, Your Honor.
All right, so let's go ahead and proceed.
Your Honor, we're here on my motion to enter final judgment of the jury verdict in this case. And a draft order has been filed. That's with the court. In my motion, we just do a brief recitation of the proceedings of the court. The case was called, the jury was impaneled. The court heard her testimony and admitted documents into evidence. And eventually there was a jury charge conference. The charge was agreed by the parties in consultation with Judge Wheelis. It was presented to the jury and the jury rendered a verdict. Questions on exemplary damages were also submitted to the jury. Because the jury's verdict finding that Michael Combs had committed fraud and by fraud disclosure was not unanimous, the question of exemplary damages was not submitted to the jury for further consideration. The question of attorney's fees was not submitted to the jury by a decision of Judge Wheelis. The jury awarded $1.3 million in actual damages and $262,500 in future damages to the plaintiff. To the counter petitioner, Mr. Combs, the jury awarded $30,000 of actual damages. The court accepted the verdict, signed it, and the parties in the jury were dismissed. So shortly after that, on July the 12th, we filed our motion to enter judgment on the verdict. Mr. Galini filed a response and objections on the 14th and an alternative proposed order. I briefed this over the weekend, and I don't need to speak to that right now, but we believe that our motion is in order. We ask that the court grant the motion in the form of the proposed final order that we filed with the court. If you'd like me to respond to Mr. Galini's objections now, I will, but other than that, I'll leave it at that.
All right, Mr. Galini.
Yes, Your Honor, we filed an opposition to that. First of all, for all aspects of it, is at least for the damages are well in excess of what was pled by the plaintiffs under Rule 47 of the Texas Rules of Civil Procedure, and being $1.5 million, excluding interest. And we believe that, and we certainly object to that as being excessive and above and beyond anything within the boundaries that a reasonable jury would have found, based upon the evidence admitted in trial and based upon the pleadings that the court has had active through this proceeding as well. We have filed, and it has not been set due to just trying to get it through the system, a motion for judgment NOV, which may be a little premature right now, depending, but we'd ask that the court take its time at least and maybe look at that before it issues judgment that's in excess of what was pled for on this. And then, Your Honor, alternatively, we additionally did file with this court a proposed judgment with an amount that we do believe not to be excessive and more in line with what the evidence showed at the jury trial, as well as within the pleading.
Is there anything in the rules or case law, and I don't know that this has happened in my court before, maybe it has and nobody's brought it up, but if you plead, for example, up to $1 million and you get in excess of $1 million, what is the remedy in that? Well,
Your Honor, under rules or Texas Rules of Civil Procedure 47, that's the maximum amount, and it's a shall plead that. And also, if I can find it real quick, there is case law that states that. Let me see if I can pull it up real quick.
does that cap the damages, or kind of how does this?
It states that it does, and Your Honor, there is.
State that it does. Kit, we're going to need to have that brief. This was not argued in his objection.
Oh, it is. Okay.
This is not an objection. This is a new argument he's presenting to the court on the fly right now. The motion, the objections that Mr. Galini filed were not phrased as a motion for judgment, notwithstanding the verdict. The civil procedures say that the issues presented to the jury shall conform to the trial. During the trial, there was a lot of discussion about damages that were potentially in excess of $1 million. We had a charging conference. There was an opportunity to request an instruction be made to the jury then. That instruction was not made nor requested. And so because
this is my thought at this point, I'll go ahead and just sign the judgment, Mr. Galini, if you want to do a remitter or something like that based on Rule 47. I'm not saying that it's not come up in my court where somebody has gotten in excess of the amount pled. And so if there's supposed to be a remitter or something, I'm not saying there should be. I think that would be the correct or a JNOV or a new trial or whatever. but I'm gonna go ahead and enter the judgment as requested, and then you can try to fix that if you want to with additional, but I do want a briefing on this to see.
Beyond the amounts, there are other aspects of it that need to be addressed, such as items that they're requesting be put into a constructive trust that are certainly not items that should be. And would you like that addressed at another time as well? Or
Is this something the jury found, or is this something Ms. Farrell?
Judge
something
Wheelis imposed a constructive trust over particular assets immediately following the jury verdict. To keep them safe pending the rest of these proceedings. So the constructive trust has already been imposed from the bench by Judge Wheelis. I think it's reasonable for both sides to know what should happen with those assets. I am not sure what assets are. Constructive trust was imposed in Mr. Combs's possession. So I don't know what assets are actually available and subject to that trust.
And Your Honor, if you'd like, we can certainly try to work together on that. I have instructed Mr. Combs in accordance with the fact that there's really no rules in place, and Judge Wheelis stated that we'd have to work later to get those terms together. I did advise him to keep any and all assets that were discussed that day in as though he's a constructive trustee and in constructive trust. So he is well aware of that and is doing that. But is there a time, and how would you like us to address the constructive trust issue?
I'm trying to kind of think this through. So would the constructive trust be part of the judgment, or is this a separate order, or kind of how is, I wasn't there for the trial. So
in the final judgment that we've proposed for the court to sign, in paragraph K, we've addressed the constructive trust. It says the court orders that, J and K, that assets subject to the constructive trust shall be held subject to the further order of the court or transferred to the plaintiffs in partial satisfaction of the judgment. So we recognize that there needed to be some further consideration about the value of those assets and exactly what assets we're talking about and whether those would be ordered. I mean, there are a number of things that could happen to those. They could be transferred outright. There could be a receiver appointed, and there's a number of things that could happen with those, all of which, of course, is also subject to Mr. Combs's rights to, it's 2 pieces of real property, cash of a unspecified amount. We have cash in the amount of $172,000. That was the amount that was discussed on the day of the jury verdict, but I understand that there's actually probably less cash than that. A 1 ounce gold coin and a future pension benefit.
Your Honor, there's really one piece of real property that was ever subject to it. At the trial, they did throw in a piece of property that is the property of Mr. Combs, and that would be really the one item that we're most concerned about being thrown into a constructive trust at this time.
Okay. Sorry, Your Honor, Judge Hoffman, we're going to have to request the transcript from the constructive trust that Judge Wheelis imposed after the verdict was rendered. The property at Laguna Vista was absolutely subject to the trust that he imposed. And the reason why he imposed the trust is because that asset is a non-exempt asset that was in the possession of Mr. Combs. The jury heard extensive evidence about the funds that were used to purchase that asset. And so rather than re-argue the trial, I think we should request the transcript of what Judge Wheelis said about the constructive trust.
That's perfectly fair. How do you want me to deal with the judgment as submitted? Does it need to be? Can you print that out for me, Rhonda, and bring it to me?
Your Honor, if you're going to sign the judgment, regardless today, subject to anything that I might file later, really big thing I'd ask is that maybe we just raise the constructive trust to be addressed parties at a later time.
And that's what the proposed judgment already says. Okay, if you look at paragraphs J and K, It just specifies that those assets are to be held subject to the constructive trust, because that's what Judge Wheelis ordered. And then paragraph K says the court further orders that those assets shall be held subject to further order of the court or transferred to plaintiff in partial satisfaction. So it leaves open that we would deal with those assets at a future date.
Just so long as there's no ability to act on it at this point while we're still, going through things.
I'm waiting. Rhonda, are you putting that out? I just want to take a look at it. Are you guys being safe? I know the rain has been kind of crazy in certain parts of town.
Not where I am. I'm down in Houston area, so
Yeah.
it's boring here. Is it interesting in Dallas?
Oh yeah, we had flash floods. Cars were floating around downtown. It was
Oh my gosh.
bad, yeah. It was covered and had national news coverage.
That's kind of where we're at. Like I said, we lost everything as far as internet and phone yesterday afternoon with the first rains, and still hasn't come up.
Oh wow.
And we had sunshine after that rain, and then after that, it's just rained like a cat and dog, and it's still doing it right now.
Yeah, I was able to get in okay, but my staff had a lot of problems getting in. I came in down on the tollway, and it wasn't super bad.
Rhonda, are you able to find that, or do you want me to email it to you?
I think she's found it. She just having a problem printing it. I'll
Oh,
take a look at it and edit the language if I need to. And
there she
oh, there
goes.
she is. How many does she have?
Your Honor, I did have another issue on this with our objection, and that was on, and this is where Miss Farrell and I vehemently,
Grab the attorneys if you can.
this is on the prejudgment interest on this. The court has the discretion to determine the prejudgment interest on this. And first of all, there are items that Mr. Combs has held from the beginning through the pendency of this, because first of all, the plaintiffs wouldn't take them until this was all resolved. But he's held it in the same condition that he has before, being the house in Irving, also the gold coin, and several other items that we asked that the court not subject to prejudgment interest, as well as take into consideration the fact that we had been scheduled for trial for 2 previous years, and the postponement was never a continuance on our part, but because of COVID and court closure. I realized that hurt the defendants or the plaintiffs as well as the defendants, but the defendants are the ones who are penalized heavily for something that had really never happened before.
Well, probably just wait. Let's grab the attorneys for him. All right. So what paragraph is prejudgment interest?
Prejudgment interest is on F, and it's literally requesting $175,712, which, like I said, a great sum of that is the house that's been.
Why don't we deal with this the same way? And that I don't recall, there's been all these Supreme Court orders about abating this and abating that, all the emergency COVID orders.
Oh,
I don't know if any of them abated prejudgment interest. They may have. I don't recall that. But if you find something in there that says that I have the discretion to abate prejudgment interest because of COVID, because of these delays, I'd be glad to look at that. But otherwise, I'm probably not going to abate it.
Okay.
All right, guys. Anything else?
And so are you going to look at the constructive trust language?
Yeah, I looked at it. I think it's fine. It leaves it open. It stays in your client's custody until further order of the court. So it orders you though to on the 310 Beverly Parkway, the 1101 Laguna Vista, cash them out of $172,000, a 1 ounce coin, and a future TMRS pension benefit. That those will all be held in constructive trust and then either be turned over or yeah, I think it's fine. I think it's fine. So, all right, guys, you guys have a great rest of your day, okay?
Thank you, Your Honor. You're going to sign that judgment